Okay, welcome to lesson 12 and video 6 of marriage practice and procedure. This will be our final video. Remember last time we covered lessons 10 and 11 on the first two sections of Canon 1095. Section 1 on lack of due reason, and Section 2, the most important ground of nullity, the most frequent ground, lack of due discretion. Now we're moving on to lesson 12, section 3, lack of due competence. Among these three, lack of due competence is probably the second most important ground, but both it and lack of due reason lag far behind number 2, section 2, lack of due discretion. Okay, when we were talking about lack of due discretion, what we have in mind is a focus on the person's judgment. There's a problem with the person's judgment. That's why they're lacking in discretion in marrying, discretion about the rights and duties of marriage. With section 3, we're going to have a different focus. Section 3 is about the situation where there is an inability to consent because the person cannot, consent doesn't happen because the person has the inability to assume the essential duties or obligations of marriage. And the reason for this inability is because of a cause of a psychic nature. So we've got a real inability to undertake, to assume the obligations of marriage, and the reason for that is a cause of a psychic nature, a psychological problem. Because we're talking about a psychological problem, they're almost always in a case under Section 3 of Canon 1095. Almost always you will need a report of a psychologist or psychiatrist, an expert report. Those reports sometimes are used in Section 2 cases, but are almost indispensable in Section 3 cases. Wren, in his book at page 44, he summarizes this provision, again, Section 3 of Canon 1095, and he describes it as referring to people who are not strong enough to assume the essential obligations of matrimony due to causes of a psychic nature. So let's think about the source of this inability to assume the duties of marriage. It's not an extrinsic source like imprisonment. You can't be a good husband because you're in prison. Well, that's true. Prison would prevent you from fulfilling your duties, but we're not talking about that type of cause, not an external cause of your being, say, confined. And it's not a physical cause either. For instance, illness. You have some very debilitating illness, so you're not able to care for other people. You're not able to help with the children. It's not that type of issue either. Those are not the grounds that Section 3 is talking about. Rather, Section 3, in the first instance, keep in mind this word inability. Inability to assume the essential obligations or duties of marriage. Remember, it is a true inability, not just difficulty. It's not just that this person's going to struggle to fulfill the duties of marriage, but a true inability. What would that look like? Again, we know the inability is based on causes of a psychic nature, so we're going to see this ground present where there's some type of psychological disturbance. And Woodall gives us, and he's at about page 392, he gives us some reasons. And here are some of the ones he gives us. Severe depression, severe clinical depression, he says, obsessive compulsive behavior or obsessive compulsive disorder, paranoia, schizophrenia, and he also lists transsexualism. So these are some possibilities of significant significant psychic causes that could make a person unable to assume the duties or obligations of marriage. There could be others too, but we want to talk about these examples just so you have some examples in mind of these serious issues um, that would qualify for this ground of nullity under Canon 1095, Section 3. Okay, well, we just said you've got some problem of a psychic nature, and because of it, you are unable to assume the essential duties of marriage. Okay, that's what the canon says. Well, what are these essential duties? What would be the things that you are unable to do if you are suffering in this way? Again, remember, it's not just about someone having difficulties in marriage, but this is a true inability to fulfill these obligations. Again, this is, I believe, also in Woodall, and he gives us some of these basic responsibilities of marriage. So I think it's helpful to see that as we're thinking about the possible psychic causes, would they make the person unable to fulfill these types of duties? What are the essential duties of marriage? Accepting children, is the person able to accept children? Caring for the children, obviously. Fidelity, is this person able to be faithful to another person, or is there some psychic reason, some psychological reason that he isn't able to, some disorder? Permanence, is the person uh, able to undertake a lifelong commitment to another person? Um, Now, just because the person ends up, say, cheating on the other person, that doesn't mean they were unable to uh, fulfill the duty of permanence. Um, it That could be the fact they did not fulfill the duty. Does that mean they necessarily were unable? Kind of a fine line here, but keep those in mind. We're talking about, with 1095, a true inability, not just difficulty. Oh, I've struggled with fidelity and turned out I was not always faithful. Well, that might or might not mean that I was truly unable. Was I truly unable because of reasons of a psychic nature to maintain fidelity? That's what a case like this would look at, and also to maintain a heterosexual relationship. Is the person able to give and accept another person in this heterosexual relationship? Um, Woodall also reminds us not only to look at the expert's report, but also to patterns of behavior in the person's life. The popes have been critical about judges turning over their own judgment to that of psychological experts. What are some areas some factual areas to investigate if there's a case like this? This probably would not be your role in investigating, but this is just to tell you how these cases play out so that you're informed and you're able to advise other people. One question is severity. How bad is the condition, the psychic condition that the person has? Is it truly disabling? Is it incurable? Is it curable? Etc. Also, the question arises of antecedents. Antecedence. Antecedents. Does the psychological condition exist at the time of marriage or before? Usually, it has to be existing at the time of marriage to qualify for this ground. However, if the problem is so deep seated that it was essentially inevitable that problems would arise, then it's possible that you could both look further back and look further ahead to say, yes, maybe there wasn't evidence of this problem at the time of marriage, but these other facts show that sooner or later this was bound to happen because of this person's disorder or psychological makeup or something. Wren also, these things to look into that we're talking about come from Wren, and these are at pages 47 to 49. One final thing he mentions is relativity. Relativity means your inability to fulfill obligations. Are you absolutely unable to fulfill the obligations of marriage? That would mean that would be called absolute. Or are you only unable to fulfill these obligations with this particular other person? Is this particular other person you're married to, does your own spouse, in a sense, aggravate your own condition so much? Or is she of so little help that whereas maybe you could have been happily married to someone else, this person you could not? It's very interesting that Wren at least raises this possibility that this kind of condition, this inability, maybe it could be relative. Maybe you could have it with one person but not have it with another. And if you do have it with the one person, you could say, yes, at least as applied to this person, I was unable to assume the duties of marriage because of psychological reasons. Again, if there really is a mental disorder, there's going to be probably a need for an expert to be involved. These are quite difficult cases. You may need to consult the judicial vicar for advice and going forward, but it's these psychological causes that you're looking for here. Okay, that is really the conclusion of our lesson 12. That's all there really is to say, other than if you're looking for a film on this issue, you might think about the film A Beautiful Mind, which is about a very brilliant man, but also a quite disturbed person and with some real psychological difficulties. But the movie also is very much about his marriage, and think about that movie in terms of marriage nullity cases, especially canon's Canon 1095 Section 2 on discretion and Section 3 on lack of competence. One final thing, though, that I'd like to do, if you remember, we are in these last 3 lessons, we're focusing on Canon 1095 because it's so important, especially Section 2 on lack of due discretion. But as we also said, there actually are several other grounds of defects of consent that can invalidate the marriage. And we talked about some of them in video 5, but I want to touch on a couple more and then pause in particular to talk about simulation. So we'll go through this list. Again, there's about 10, but we'll go through them fairly quickly. Some we've really said everything we need to say about already. One of them, canon 1096, is ignorance. We discussed that in the last video briefly, but we also discussed it in Canon Law 2. Feel free to ask questions if you have any, but the canon probably will be quite clear to you. The same with the next two grounds: error of a person and error of a quality of a person. We touched on those briefly in video 5 and covered them more extensively in Canon Law 2. Again, we can address them if you need to otherwise. But let's talk a little bit more about some of the others. Deceit is the next ground. Deceit. That's Canon 1098. Now, usually deceit in canon law does not make an act invalid most of the time. And so here under canon 1098, deceit in getting someone to marry you, it's only going to invalidate the marriage under some circumstances. So here are the circumstances. There has to be a deceiver. Some person is deceiving one of the spouses. That may be the other spouse, or it may be another person. Maybe it's the mother of the other spouse. So there's a deceiver, and there's some type of deceit. What is the deceit? Let's put up our elements here. Deceit is the ground of nullity. This is canon 1098. We have to have a deceiver. The deceit, the purpose of the deceit is to secure consent. So you're being deceived about something to make you consent to marry the other party who you otherwise would not marry. But the deceit has to be about a specific subject. It has to be about a quality of the other person that by its nature could seriously disrupt marital life. So it's not just any type of deceit. Oh, she's a natural blonde, and she's not really. She's just been dyeing her hair. Well, that issue is that might be deceit. It might really be real deception, but it's not the type of issue that could seriously disrupt, objectively and seriously disrupt the marital life. At least not usually. One wouldn't think. So it really has to be objectively about a serious matter that could cause real harm in the marriage. A good example is inability to have children. I would not have married her if I had known she could not have children. But her mother told me there was no reason to believe she couldn't have children, while her mother knew that the daughter could not have children. That would qualify under this ground, something like that. But keep in mind that the deceit, it's the reason for the deceit is to secure consent, and the judgment about how serious the deceit is, it's a very objective judgment. Okay, good. The next ground, by the way, our previous ground of error about the person, that is that's similar to deceit, but there the judgment is the type of error versus the deceit here. It's more subjective under that ground, and here it's a much more objective rule. So this deceit canon is quite hard to satisfy. Okay, our next ground, canon 1099, radical error determining the will. What does that mean? It's a radical error about marriage, a very serious error that one of the spouses has about the nature of marriage itself. So it has to be an error, a mistake that the person has about one of the key things of marriage. So we'd say probably one of the goods of marriage: unity, indissolubility, or sacramentality. Not just a minor issue, but a real misunderstanding of the nature of marriage itself. But not only that, the person doesn't just have so what would an error about unity be? Well, unity is exclusivity. If the person did not think marriage was exclusive, that person's error would make the marriage invalid. He has a faulty understanding of marriage. But the error has to determine the will. What does that mean? That means that not only does he have this very serious misunderstanding of marriage, but also that's what gets him to enter into the marriage. So let's take an example: indissolubility. Your error is you think marriage is dissoluble. You think I can just try marriage, or a spouse can try marriage, and if it doesn't work out, one of the spouses can leave. That's the error. Does it determine the will? Take an example. H, the husband, or potential husband, he thinks that marriage is dissoluble. He does not think that marriage by nature is indissoluble. However, he intends, he's very in love with W, his future wife. He very much intends to stay with her forever. So he does not intend ever to leave her. He intends to commit for her, to commit to her permanently for life, even though he doesn't think marriage of its nature is a lifelong commitment. Well, he has an error. He's misunderstood what marriage is. He does not understand that marriage is by its nature permanent. However, his error does not determine his will. He's not saying, well, I'll marry W because if it doesn't work out, I can leave. He's saying, no, even though his understanding is that marriage is not permanent, he intends permanence in his own marriage. You could say the same with exclusivity. He may not think that marriage is exclusive or have the property of unity by its nature, but he intends to be faithful only to his wife. Then he might have that error about the unity of marriage, but it's not determining his will. How do you tell if it determines their will? There's a really easy test. If he had known the truth about marriage, would he have married her? If we could go back in time and correct his mistake and say, hey, you're wrong about marriage. Marriage is indissoluble by nature. Would he still marry her? Well, H says, well, yes, of course, because I intended to be faithful for life to my wife and intended never to leave her. So even if I was wrong about marriage, that didn't matter so much because I've always intended to be true. So you have to keep in mind it's not just a mistake to satisfy this ground in 1099, not just a mistake about a fundamental property of marriage, but also one that the spouse acts on, that he gets married relying on his error, and if he had had a different understanding, he would not have gotten married. Okay, 1099, and now to our ground of simulation. This is our, as we said, after canon 1095, after the lack of due discretion, lack of due competence, lack of due reason, the next most important types of consent problems have to do with simulation. What is that? This is in canon 1101. Simulation is a, quote, a knowing, deliberate exclusion by a positive act of the will of marriage or of some essential property of marriage, end quote. You can find that in canon 1101 or Woodall, pages 398 and 399. What does that mean? So you're either excluding marriage completely. That means you're up there at the altar getting married, but you don't really mean it. You don't really mean to marry the person. The example we had of if you're getting married just to solve somebody's immigration problem, that would be kind of a classic example of total simulation. You don't intend to marry the person at all. You're only getting married for the green card, for the passport, for the legal status. That's total simulation. But there's also partial simulation. So we say number one, simulation of consent is what we're talking about, canon 1101. Number total simulation, exclusion of marriage itself. I'm up here saying I do, up at the altar, at the judge, wherever, but I don't really mean to marry this person at all. I'm only doing it as a kind of a fiction. But then we have partial simulation. The marriage also is invalid, not only if you exclude marriage entirely, but if you exclude an essential property of marriage. And what are the essential properties? Remember them from Augustine. The bonum prolus, the bonum fide, the bonum sacramenti, and then our later ground that comes up later, our sort of more Vatican II type ground, the bonum conjugum, the good of the spouses. But let's talk more about the first three, the more common ones to begin. Exclusion of the bonum prolus. This means that you're excluding children. we're not going to have children. It doesn't just mean you don't want children. It doesn't mean you hope you don't have children. It doesn't mean, boy, I really don't care for children. I hope they don't come. Doesn't mean, oh, I'm not sure if I want children. It's a person has really determined, um, with knowledge and deliberation, I am not going to have children. Um, that would be exclusion of the bonum prolus and would make the marriage invalid. What would be another one? Exclusion of the bonum fide. I'm not going to be faithful to this person. I'm in another relationship and I'm not going to break it off, even though I'm marrying this one person. Well, if that's the situation, I've got two relationships going on at the same time, and I don't intend to give up either one. That shows that I don't really intend to be to be faithful to the person I'm marrying. And again, it's a deliberate exclusion. Really saying, um, I I just I'm not going to live as if marriage is exclusive. I'm not going to treat it that way. And similarly, with the exclusion of the bonum sacramenti, that would often be described as the kind of if the person reserves the right to divorce. Well, I'm marrying you, but if it doesn't work out, I reserve the right to get divorced. That would be exclusion of permanence, so that would make the marriage invalid. Um, okay, that more or less covers simulation of consent. As we said, the bonum conjugum is kind of a new ground. We covered this in marriage class, sacrament of marriage. It's kind of a new ground, but there are cases on this ground of people excluding the good of the other spouse. So that's something to keep an eye on. But the other exclusion of one of the other three bona, the bonum prolus, bonum fide, bonum sacramenti, are going to be more common grounds. Okay, that ends simulation. Let's just talk about two more grounds and then we'll wrap up the semester in lectures. Another, Canon 1102, conditional consent. Conditional consent can make the marriage invalid, but sometimes it doesn't. This means you consent to marriage, but it's on the basis of a condition. Um, I consent to marry you because you're pregnant, and if the child is mine, I consent to marry you. Um, this marrying according to a condition, it might or might not be valid. If the condition is a future condition, then it's invalid. I marry you, but the condition is that you have children, that you give me children. Well, that's a future condition. We don't know if that's true yet. So that would be invalid consent. But if I'm saying I marry you because you're pregnant and I think it's my child, I marry you if this is my child. That could be tested at the time. If it's a past or present condition, that could be tested. So that type of conditional consent, it could be valid. When is it valid? It's valid if the condition is met. I say I accept you only if that's my child that you're carrying. Turns out it is my child, then the marriage is valid. Now, needless to say, the church does not really like conditional marriages, and for lawfulness, under the same canon 1102, you're really supposed to have the bishop's permission to marry under a condition. But it can be, as I say, it can be valid if the condition is present or past, and if it turns out to be fulfilled, it turns out actually to be the case. Okay, last ground, force or grave fear. This is canon 1103. This is where someone is essentially forced to marry another person. The force has to be imposed from the outside, so it's not like psychological force. We're not talking about Canon 1095, Section 3, I felt compelled because of psychological reasons to do something that maybe was not a good thing for me to do. But the force is imposed from the outside, probably from another person. So probably not about pregnancy either. Often pregnancy might be treated under Canon 1095, Section 2. Pregnancy, if it's pregnancy combined with the parents trying to force the parties to get married, maybe that might satisfy the requirements. Um, but two requirements: the force is imposed from the outside, and marrying the other person is the only means of escape. That's the only way to end the tension that's being imposed on you. Um, Arranged marriages can uh, result from force, so we have to be careful about arranged marriages, but they also can be valid. An arranged marriage can be valid if the family arranged it, but if the parties truly consent and agree, they can be valid. Here's another example in addition to, say, the pregnancy or the the parents forcing their children to get married because of the pregnancy or some other reason. Someone, you're breaking up with someone and they're very distraught and they say, I'm going to kill myself unless you marry me. Well, they're really forcing you. That's a force. And the only way to end the tension is for you to marry the person. So that would satisfy, or likely would satisfy, the requirements for force and fear under Canon 1103. Okay, that's essentially the end of our list of possible defects of consent. So we've at least touched on, I think, all of them. And that's the end of our course, too. So thank you for some very good discussions. I'm sorry that we could not finish the course together in person, but feel free to contact me with any questions, and I look forward to reading your papers. Thank you very much.